So before starting our discussion on topic number 2 of your syllabus, that is initiation of criminal case, wherein we will be mainly discussing law relating to FIR and different issues involved in that particular law relating to FIR. So before that, whatever we discussed in the last class, if you have any question regarding it, or if you have any comment on it, then you can go ahead and ask or say whatever you want to say. Different segments of code of criminal procedure. So now I delivered that lecture in I section. So I think it was slightly better in comparison to what I delivered in your lecture, in your section, because when you take lecture on a topic the second time, then generally there is improvement or addition of few things. So you can also listen to that particular lecture if you get hold of recording of it through CR of that particular section. So the idea behind discussing with you main segments of CrPC, I do not know whether I was able to reach up to that level of delivering that particular idea wherein it has some benefits for you. But the idea was that before venturing on to discuss such a comprehensive legislation like CrPC, one should have a fair idea about what is there in CrPC under different chapters or under different provisions, a basic idea. So that was the theme of yesterday's lecture, wherein I told you that you have to divide the CrPC into 3 segments: pre-trial proceedings, trial proceedings, and post-trial proceedings. And then accordingly, you should know which chapters of CrPC are relevant under which segment. So in pre-trial proceedings, there could be 2 kinds of pre-trial proceedings: by police, by courts. Under police wala segment, you have chapter 5, 6, 7, and 12 which are relevant. Under magistrate wala or criminal court wala segment, you have chapter 14, 15, 16, and 17 which are relevant. When we are talking about trial segment relating to trial, then chapter 13 becomes relevant. Along with that, there are 4 kinds of trials, provisions relating to which are provided under chapter 18, 19, 20, and 21. Along with that, recording of evidence is also a relevant chapter under trial proceedings, that is chapter number 23. There are some general provisions relating to trial provided under chapter number 24. Once you have completed the conduct of the trial, you are required to write your judgment. Provisions relating to judgment are provided under it was, I guess, chapter number 28 or something. I could not recall it, 27 or 28. And the reference and revision are relevant to be studied, which are provided under chapter 30. For post-trial proceedings, you have appeal, chapter 29, which is relevant. Chapter 28, submission of death sentence for confirmation to High Court is relevant. Execution of sentence, remission of it is relevant in post-trial proceedings, which is, I'm forgetting it, but it is chapter number 32, just before bail. Chapter number 33, which deals with bail, is relevant for all these 3 stages: pre-trial, trial, and post-trial proceedings. And all these provisions, they will constitute to make 21 chapters of CrPC. So this is the nucleus of CrPC. So 21 chapters of CrPC, which we could study under 3 different segments of CrPC. They forms the nucleus of the CrPC. Shuru ke 4 chapters you have to study before starting any discussion on CrPC. So if you add that number also, 2, 3, 4, and 1 relating to definition and all, then the number becomes 25. So these are the chapters that forms in one way or the other way the nucleus of CrPC. 21 plus 4. Then you have some peripheral chapters. Executive magistrate ka power is provided under 8 and 10. Maintenance relating provisions are provided under section 125, chapter number 9. And then you have certain provisions relating to preventive power of police under chapter number 11. So 8, 9, 10, 11 becomes relevant as peripheral provisions providing for power of executive magistrate and police to maintain law and order and to take preventive action. Then you have some chapters relating to irregular proceedings, a chapter wherein provisions are provided which are applicable to if the accused person is of unsound mind. If the offense is against administration of justice, then you have chapter number 26, I guess, 25 and 26, or 26 and 27 are relating to accused person or offenses against administration of justice. So number is not that much important, but still you should have an idea about this is the way that CrPC has been drafted. So if you have any question on it, you are welcome. Uske baad we will start with the new topic. So in today's lecture, first we will discuss briefly the definitions of cognizable and non-cognizable offenses, because from today we will be starting topic number 2, that is initiation of a criminal case, and under this topic the most important part would cover law relating to FIR, and almost all cases that we would discuss which are given in your study material, they are mainly relating to FIR and the issues relating to FIR. So before starting our discussion on initiation of criminal case, we should have a fair understanding of the meaning or definition of cognizable offenses and cognizable offense and non-cognizable offense. So if you read CrPC, then cognizable offense is defined under 2C, section 2 clause C, and non-cognizable offense is defined under section 2L. There are mainly 3 ways of classification of offenses for the purpose of criminal procedure, and classification of offenses into cognizable and non-cognizable is one of the ways to classify offenses. And the other ways of classification of offenses are classification on the basis of right to get bail. Therein we classify offenses into bailable and non-bailable. And finally, for the purpose of trial, whether there will be a summons trial or warrant trial, whether summons shall be issued to compel appearance of accused person before the trial court, whether warrant shall be issued. So to decide all those things, offenses can also be classified into summon case and warrant case. Summons case and warrant case. So what we will do, we won't be discussing all 3 classification under a particular topic. कि भैया अलग से separate topic बना दिया classification of offenses और फिर discuss कर दी. For the purpose of CrPC, these 3 are the main classification of offenses. ये नहीं करेंगे. What we will do is that we will pick up a particular classification depending on the topic which we are discussing. So for example, from today we are starting our discussion on initiation of a criminal case, and initiation of criminal case can be done either by filing an FIR or filing a criminal complaint before the competent magistrate, and if FIR has been filed, then it would result into investigation. So it is because of this reason, it is because the nature of our topic is such that we must be acquainted with the meaning or definition of the first classification, that is cognizable offenses of offense and non-cognizable offense. So therefore, in today's lecture, I won't be discussing the meaning and definition of bailable and non-bailable and summons and warrant case, but we will focus solely on the meaning and definition of cognizable offense and non-cognizable offense. When it comes to discussing bailable and non-bailable offense, then we would do that when we will be discussing topic relating to bail. Under chapter number 4, I guess, you have a topic titled as bail. So when we will discuss bail, then we will start that topic with the definition of bailable and non-bailable offenses. So then second classification would come into picture. The third classification of offenses for the purpose of CrPC, that is classification into summon case and warrant case, that we will discuss when we will discuss chapter relating to or topic relating to trial. That is, I guess, topic number 6. topic relating to trial would fall under topic number 6. So that classification we will discuss at this stage. So in today's class, we are discussing the classification of offenses into cognizable and non-cognizable, because it is relevant for the purpose of making a foundation of the topic that we will be discussing after, in today's class, and continue our discussion in classes to come, in lectures to come. So a cognizable offense is defined under section 2C. Non-cognizable offense is defined under section 2L. Now, the basis of this qualification is power of police to arrest. And if you know this basis, then you can easily write your definition as per the provisions of CrPC. Know the basis, write the definition. So it is not important to know the actual words of the definition written in the CrPC. Rather, what is important is to know the basis. That what is the basis of classifying offenses into cognizable and non-cognizable. So the basis is the basis. So moot question is basis. क्यों कर रहे हो इनको classify? Basis क्या है इसका? ठीक है? मतलब what is going to be the purpose for classifying, and which purpose are you going to serve by classifying offenses into cognizable and non-cognizable? So the basis of this classification is power of police to arrest and investigate a case. Power of police to arrest and investigate a case. ये जो basis है power to arrest, this you will find in the definition itself. और जो power to investigate है, this is not there in the definition. This is found under 156 and 155 of CrPC. When you will read 155 and 156, then you will get to know about कि हाँ भैया cognizable and non-cognizable का जो classification we studied, उसका एक basis तो था power of police to arrest the accused or suspected person, और जो दूसरा basis था वो है power of police to start an investigation. So if I am saying that the primary basis of classification of offenses into cognizable and non-cognizable is power of police to arrest, then you can read the definition once you know this basis. So that what does the definition states? That cognizable offense means an offense for which, or you can also call it a cognizable case. So the expression cognizable case means nothing but a case involving a cognizable offense, a criminal case involving a cognizable offense. So these two expressions can be used interchangeably. So do not get confused. माइनस सेम ही रहेंगे, ठीक है जी. So CrPC is explaining it क्योंकि कहीं-कहीं पे वो ये लिखेगा in provisions cognizable case, ठीक है. So cognizable case is nothing but a case involving a cognizable offense. A non-cognizable case is one which is involving a non-cognizable offense. Okay? So a cognizable offense or cognizable case means a offense or a case in which police officer, in accordance with the first schedule or any other law for the time being in force, arrest without warrant. So for a while, just forget about this expression. So for a while, just forget about this expression which I have just changed into red. And now read the meaning. Cognizable offense or cognizable case means a case in which police officer may arrest without warrant. So therefore, the nucleus of the offense or the central point of the meaning of cognizable offense or cognizable cases, that if it is a cognizable offense, then police officer can arrest without warrant. The word may has been used. It is the discretion of the police officer. ऐसा नहीं बोला है डेफिनेशन ने कि हर एक कॉग्निजेबल ऑफेंस के केस में आप पुलिस को अरेस्ट करना ही होगा एक्यूज्ड को, तो एक डिस्क्रेशन दे दिया, उसकी डिस्क्रेशनरी पावर है. सो देयरफॉर इट इज द डिस्क्रेशनरी पावर ऑफ द पुलिस ऑफिसर टू arrest the accused or suspected person if it is a cognizable offense. That is why I told you that if you know the basis, you can write the definition. If you know the basis, then you can write the definition. तो कोई भी cognizable case होगा, वहां पे उसका मतलब ये है that police officer can arrest without warrant. Can arrest without warrant. And this is the preliminary meaning. Only by reading 2C. हो सकता है हमारा मतलब थोड़ा थोड़ा expand करे with the passage of our lecture, but initially you have to keep this fact in mind that because the basis of the classification is power of police to arrest, so therefore meaning would follow accordingly. Similarly, a non-cognizable case is one in which a police officer has no authority to arrest without warrant. So I'll stop here. If you want to ask something on this, you can go ahead and ask. Then we will move on to the red portion, why it is written first schedule.
Sir, is there a lot of misuse of this power to arrest without a warrant?
That we will discuss later on. That is something which needs a detailed analysis. What I have discussed now is that the basis of classifying offenses in cognizable and non-cognizable is power of police to arrest. And if you want to know the definition that is provided under 2C and 2L, then you should know this basis. If you know this basis, then you can write the definition. In cognizable case means a case in which police may arrest without warrant. A non-cognizable case is a case in which police cannot arrest without warrant. The exact wording is police has no authority to arrest without warrant. ठीक है जी. So now, could anyone tell ये जो रेड वाला पोर्शन हमने हाईलाइट किया था, what does this mean? Why is it there in the definition? Why the definition is saying that in accordance with the first schedule or under any other law for the time being enforced.
So there can be special laws also in which there would be cognizable offenses as well as IPC and CrPC.
ठीक है जी. हाँ. Any other thing which anyone wants to add? बताओ भाई, कुछ तो बताओ. ऐसे तो ये होगा कि I am beating the drum. Now, if I ask you this question, are these नहीं जो आपने लिखा है, I read it. No. So suppose if I ask you this question, let's discuss it other way around. Is the definitions both of cognizable and non-cognizable offenses, remove the is, are the definitions of both cognizable and non-cognizable offenses giving you any clue about that which offenses are cognizable and which are not? I'll repeat myself. Are the definitions of so somebody is saying first schedule would lay out कि भैया कौन सा अपराध कॉग्निजेबल है, कौन सा नहीं है, ये जाओ और पता कर लो फर्स्ट शेड्यूल से. तो शायद एक तो ये कारण है to write this, a case in which a police officer may, in accordance with the first schedule, so that is why they have provided first schedule. That is why they are saying go to first schedule and find out कि हमारा कहने का आशय क्या है, what we intend to say. But once again, if I ask you this question, are these definitions giving you any clue about which offenses are cognizable and which are not? Can you make a list of such offenses which are cognizable and non-cognizable on the basis of these definitions? Anyone just say it in yes or no. Can you make a list of all cognizable and non-cognizable offenses under IPC or under any other criminal statute on the basis of this definition? No.
No.
It's a big no. ठीक है? तो इस वजह से आपको ये क्लू दे रहा है इस एक्सप्रेशन के हिसाब से. ये तो हम बता रहे हैं आपको that in a cognizable case police can arrest without warrant, in non-cognizable police cannot arrest without warrant. बट जहां तक बात उस लिस्ट की है कि कौन सा अपराध कॉग्निजेबल होगा और कौन सा नॉन कॉग्निजेबल होगा, वो आप इस परिभाषा को पढ़ के नहीं बना पाओगे. रादर इट हैज टू बी डिसाइडेड इन अकॉर्डेंस विद फर्स्ट शेड्यूल. It has to be decided in accordance with the first schedule. Therefore, this expression in accordance with the first schedule is actually inserted to give you an idea. Okay, look, gentlemen, if you want to make a list of all the offenses under IPC, that which one of these are cognizable, which one are non-cognizable, then refer first schedule. Refer to first schedule. क्योंकि पुलिस ऑफिसर को भी इस बात का अंदाजा कि किस अपराध के लिए उसके पास अरेस्ट विद वारंट करने का पावर है और अरेस्ट विदाउट वारंट करने का पावर है, इसका अंदाजा पुलिस ऑफिसर भी इन अकॉर्डेंस विद फर्स्ट शेड्यूल लगाएगा. इन अकॉर्डेंस विद फर्स्ट शेड्यूल लगाएगा. सो लेट्स गो टू फर्स्ट शेड्यूल which we discussed yesterday. So I am repeating myself once again. Okay. By reading the definition, you cannot make a list of the offenses which are cognizable and which are not. अगर आप सिर्फ ये डेफिनेशन पढ़ोगे 2CO 2L की तो लिस्ट नहीं बना पाओगे. तो इस वजह से जो पुलिस ऑफिसर को इट इज गिविंग पावर टू अरेस्ट विदाउट वारंट इन केस ऑफ कॉग्निजेबल केस, वहां पे इट इज क्लियरली सेइंग you will exercise this power in accordance with the first schedule. So there it is intending that go to first schedule, there you will find an answer to this question that which offenses under IPC are cognizable, which are not, or which offenses under IPC are non-cognizable and which are cognizable. इसका मतलब ये हुआ that if you want to find out which offense is cognizable, which is not, तो आपको अपना दिमाग नहीं अप्लाई करना है. You don't have to apply your own mind. What you have to do is go to first schedule. अब आ गए जी हम first schedule में. ठीक है? Now this is the first schedule, classification of offenses. Now all the offenses under IPC, जो इसका first part है, the first part of first schedule gives you a list of all the offenses under IPC by dividing them into cognizable and non-cognizable. It will give you a list. It will give you a list of all the offenses which are cognizable and non-cognizable. For example, if 121A, for example, take this sedition wala offense. 124A, take 124A for sedition because it is too much in news most of the time. Then if you want to know whether sedition is cognizable or non-cognizable, then you have to refer to first schedule. तो फर्स्ट शेड्यूल में जाके देखोगे तो यहां से पता कर सकते हो whether it is cognizable or not. अब ये पता करना क्यों जरूरी है किसी व्यक्ति को, be it a functionary of criminal justice system, be it a victim, be it the accused, क्यों जानना जरूरी है कि cognizable है या non-cognizable है अपराध? अच्छा छोड़ो बाकी को, पुलिस ऑफिसर को जानना क्यों जरूरी है कि वेदर एन ऑफेंस रिलेटिंग टू विच अ इंफॉर्मेशन हैज बीन गिवन टू हिम इज कॉग्निजेबल और नॉन कॉग्निजेबल, उसको क्यों जानना जरूरी है?
बिकॉज़ ही विल टेक द एक्शन अकॉर्डिंगली, अरेस्ट के लिए.
हाँ, एक बेटर आंसर इज जो इन्होंने कहा है कि भैया बिकॉज ऑल द पावर्स दैट हैज बीन गिवन टू द पुलिस ऑफिसर अंडर द प्रोविजंस ऑफ CrPC, द एक्सरसाइज ऑफ those powers depends on whether the offense is cognizable or non-cognizable. इसलिए उसको ये जानना जरूरी है जैसे ही उसके सामने कोई इंफॉर्मेशन आती है किसी ऑफेंस से रिलेटेड कि कॉग्निजेबल है या नॉन कॉग्निजेबल है. So if he gets information that sedition has been committed, somebody comes to the police officer in charge of a police station and lodge an FIR, तो उस FIR को लॉन्च करने से पहले भी पुलिस ऑफिसर को ये जानना जरूरी है कि कॉग्निजेबल ऑफेंस है या नहीं है. because according to 154 of CrPC, no FIR can be registered if the offense is not cognizable. If the offense is not cognizable. तो अगर आप पुलिस थाने में बैठे हो and somebody comes to you with an information or grievance कि भैया मेरी FIR दर्ज कर लो आप, तो आपके लिए जानना जरूरी है कि जिस ऑफेंस के बारे में वो बात कर रहा है whether that offense is cognizable or non-cognizable, because अगर वो offense is not cognizable then you cannot register the FIR. You have to proceed under 155. दूसरा, you cannot arrest without warrant अगर वो offense cognizable नहीं है, और अगर वो offense cognizable है then as per section 2C you can arrest without warrant, you can exercise the power to arrest without warrant, and as per section 154 you are under a duty to register an FIR, and then you are also empowered to conduct an investigation under 156. So 3 powers of police officers, they are dependent on answer to this question whether the offense is cognizable or non-cognizable. First, power to register or not to register, duty to register, not to register an FIR, power to arrest or not to arrest without or with warrant, power to conduct investigation, So it is because of this reason that expression has been added in the definition. कि पुलिस ऑफिसर का ये जो पावर है टू अरेस्ट विदाउट वारंट, इट शैल बी एक्सरसाइज्ड इन अकॉर्डेंस विद द फर्स्ट शेड्यूल और इन अकॉर्डेंस विद एनी अदर लॉ इन फोर्स. क्योंकि अगर कोई और लॉ होगा, फॉर एग्जांपल इफ इट इज द केस रिलेटिंग टू पोक्सो, तो फिर वहां पे भी देखना पड़ेगा वेदर द ऑफेंस the information relating to which has been communicated to the police officer in charge of the police station वो cognizable है या non cognizable है, वहां पे भी देखना पड़ेगा. सो जो फर्स्ट पार्ट ऑफ फर्स्ट शेड्यूल है ये आपको आईपीसी के अंदर जितने भी ऑफेंसेस है विदाउट फेल ऑल द ऑफेंसेस उनके बारे में इंफॉर्मेशन देता है वेदर दे आर कॉग्निजेबल और नॉन कॉग्निजेबल. लेट्स टेक अप some offenses which you have studied as a part of your IPC का पेपर. Let's take up murder, cognizable. Let's take up culpable homicide not amounting to murder, cognizable. Causing death by rash negligent act, cognizable. All these offenses are cognizable. But if you cause miscarriage under 312, which is punishable under 312, then non-cognizable. If you cause voluntarily hurt, to any person, then it is non-cognizable. But if you cause grievous hurt, then it is cognizable. तो आपको अपना माइंड नहीं अप्लाई करना है which offense is cognizable or which is not. इसके लिए कोई अलग से आपको थीसिस नहीं लिखना है. It's just you should know about schedule 1. You need to refer to schedule 1. आपको माइंड अपना अप्लाई करना है वहां पे जहां पे you have decided that whether the offense is cognizable or non-cognizable. Once you have decided on this question and you reached a conclusion, then you can apply your mind that as per the provisions of CrPC, police can do this, police cannot do this. Police can do this, police cannot do this. Magistrate can do this, magistrate cannot do this. Magistrate can do this, magistrate cannot do this. So IPC के सारे provisions, whether they are cognizable or not, the list is under first schedule. You can pick up any provision. Now अगर कोई आपसे पूछे कि भाई IPC के अलावा अगर किसी statute में offense is defined, तो उसका पता कैसे करेंगे whether that offense is cognizable or non-cognizable? Then for that you have to go to part 2 of schedule 1. You can write it somewhere. Part 2 of schedule 1. Classification of offenses into cognizable and bailable. Under same discussion we will have when we will discuss bail. But then I'll just refer to schedule. Thoda sa, not in detail. But today I am doing it in detail because we are referring to the first schedule for the first time. अब आईपीसी का तो साफ साफ लिख दिया कोड में, सीआरपीसी में फर्स्ट शेड्यूल में साफ साफ लिख दिया कौन सा ऑफेंस कॉग्निजेबल है, कौन सा नॉन कॉग्निजेबल है. बट व्हेन इट कम्स टू क्लासिफिकेशन ऑफ ऑफेंसेस इनटू कॉग्निजेबल एंड नॉन कॉग्निजेबल अंडर एनी अदर लॉ, देन फर्स्ट शेड्यूल प्रोवाइड्स यू अ की टू इट कि वहां पे कैसे डिसाइड करोगे आप. ठीक है जी. सो देयरफॉर फर्स्ट शेड्यूल शुड बी स्टडीड बाय डिवाइडिंग इनटू 2. फर्स्ट पार्ट इज टेलिंग यू by writing each and every offense under IPC that whether that offense is cognizable or non-cognizable or not, whether that offense is bailable or not, whether that offense is bailable or non-bailable. Okay. Now the second part of the first schedule is telling you कि अगर आईपीसी के अलावा किसी स्टैट्यूट में कोई एक्ट ऑफेंस है तो वो अगर हमें पता करना हो कि क्या वो ऑफेंस कॉग्निजेबल है नॉन कॉग्निजेबल है, देन यू हैव टू रेफर टू पार्ट 2 ऑफ शेड्यूल 1 which states that if an offense under any other law other than IPC is punishable with death, imprisonment of life, imprisonment for more than 7 years, then it is cognizable. If an offense is punishable with imprisonment for 3 years up to 7 years, cognizable. If offense is punishable with less than, साफ साफ लिखो यहाँ पे, less than 3 years or with fine, और यहाँ पे लिखा है imprisonment with of 3 years. तो इसको both मतलब रीड इट वेरी केयरफुली. अगर किसी अपराध की परिभाषा में अगर किसी अपराध का पनिशमेंट इज 3 years, देन दैट ऑफेंस इज कॉग्निजेबल. अगर 3 से कम है, लेस देन 3 years, देन दैट ऑफेंस इज नॉन कॉग्निजेबल. नाउ पार्ट 2 ऑफ शेड्यूल 1 of CrPC is giving you a formula to decide which offense is cognizable or not if the offense is under any other law other than IPC. Then it is giving you a formula. Listen, mark these words. This formula is applicable only to the laws other than IPC. IPC के बारे में तो साफ साफ स्पष्ट रूप से लिखता है ये कोड, हर एक अपराध के बारे में एक भी अपराध नहीं छोड़ता है. तो यहाँ पे कोई गेस वर्क नहीं है, ना फॉर्मूला नहीं लगाना है. यहाँ पे तो यू हैव टू वॉक बाय द बुक, यू हैव टू लुक एट द वर्ड एंड देन कंडक्ट अकॉर्डिंगली. यू डोंट हैव एनी डिस्क्रेशन टू अप्लाई अ फॉर्मूला एंड अकॉर्डिंगली चेंज द नेचर ऑफ द ऑफेंस. बट इन केस ऑफ दोज ऑफेंसेस which are there under any other law other than IPC, then it is giving you a formula that if the offense is punishable with a punishment of or imprisonment of less than 3 years, then that offense is non-cognizable. It means if such an offense is committed, then as per 2C of IPC and 2L of not IPC, CrPC, 2C and L of CrPC, police officer cannot arrest without warrant. This is about any other law. Number 2, no FIR can be registered under 154. No investigation can be initiated by the police if the offense is non-cognizable. Formula क्या है? That if the maximum imprisonment or punishment for any offense is less than 3 years of imprisonment, then the offense shall be a non-cognizable offense. If the punishment for an offense is either an imprisonment of 3 years or more than 3 years, it could be 7, it could be 10, और ये 2 में डिवाइडेड यहाँ इसलिए है क्योंकि वो कोर्ट ऑफ सेशन और मैजिस्ट्रेट अलग अलग ट्रायल कर सकते हैं उसको. वो ट्रायल की वजह से इन्होंने 3 सेंटेंस लिखे हैं. अदरवाइज अगर इसमें ट्रायल वाला पोर्शन ना होता, कॉलम ना होता, देन दिस फॉर्मूला कुड हैव बीन रिटन इन 2 sentences इंस्टेड ऑफ 3 points. इट कुड हैव बीन रिटन इन 2 sentences. जैसे कि हम अभी डिस्कस कर रहे हैं दैट इफ द पनिशमेंट, मैक्सिमम पनिशमेंट फॉर एन ऑफेंस इज ईदर an imprisonment of 3 years or more than 3 years, then the offense shall be a cognizable offense. If the punishment for an offense is an imprisonment of less than, it is underlined, less than 3 years, then in that case the offense shall be non-cognizable. तो वो जो सवाल मैंने आपसे पूछा था, can you make a list of the offenses, which offenses cognizable and non-cognizable, तो उसका सीधा सा जवाब है हाँ भाई मैं तो नहीं बना सकता लिस्ट, but there is a list under schedule 1 when it comes to offenses under IPC. Or if I say what about offenses in any other statute other than IPC, then you can say that for that you can refer to part 2 of first schedule. It gives you a formula It provides a formula कि कौन सा अपराध जो cognizable है, कौन सा नहीं है, वो हम decide करेंगे on the basis of the quantum of the punishment. If punishment is less than 3 years of imprisonment, then that offense shall be a non-cognizable offense. भले ही वो offense पोक्सो में लिखा हुआ हो, भले ही वो offense SC/ST Act में लिखा हुआ हो, भले ही वो offense किसी और criminal statute में लिखा हुआ हो. However, and this is an explanation to it, however, a statute other than IPC, special statute creating offenses may decide to specifically provide that XYZ offense shall be a cognizable or non-cognizable offense. तब ये फॉर्मूला नहीं लगेगा वहां पे. अगर उस स्टैट्यूट में जिसके बारे में आप बात कर रहे हो, XYZ स्टैट्यूट, उसमें लेजिस्लेचर हैज प्रोवाइडेड एक्सप्रेसली that ABC offense is cognizable or non-cognizable. If legislature has done so, then this formula will not be applicable. But अगर उसमें आपके पास कोई clue नहीं है, for example, if you are flipping through the pages of POCSO and you do not find that which offense under POCSO is cognizable, which is non-cognizable, so you can refer to the formula given under Part 2 of Schedule 1 of CrPC and accordingly apply it. So this is in brief the discussion on the definitions and the expression which is used under 2C of CrPC. So if you have any problem, you can go ahead and ask. Then I'll discuss with you a little bit more about cognizable and non-cognizable, going beyond arrest. थोड़ा सा तो मैंने अभी बता दिया आपको FIR investigation, but I will show you a table of distinction between these two offenses, and then we will wind up our lecture. ठीक है जी, I am moving ahead. If you want to ask anything, you go ahead and ask.
So last year I was reading the Dowry Prohibition Act.
Yes.
Section 8 में लिखा हुआ है that offences under the act are treated as cognizable offences only in certain limited purposes. So this certain limited purposes means that we will check with Schedule 2.
Yes.
So what
Schedule 1.
All right. And so is there any reason for writing this in the act?
Like that is why I added to my discussion कि ये जो फॉर्मूला CrPC में दिया हुआ है, ये जनरल फॉर्मूला है. बट व्हेन यू आर मेकिंग अ स्पेशल लेजिस्लेशन, you are doing that to take care of a specific problem. So if the nature of the problem is such that legislature thinks it appropriate to mention it expressly, or that which offense under this act shall be cognizable or not cognizable, then it can do so. So Dowry Prohibition Act, because the nature of the legislation was such when it was enacted by the legislature, that along with the legislature there was a pressure from the society and as well as from the judiciary that we should hit at the problem of dowry deaths and problem relating to dowry. That is why they have expressly mentioned it that all offenses under this act are cognizable. तो वहां पे आपको ये पनिशमेंट में जाने की जरूरत नहीं है कि कितने का पनिशमेंट और कितने का नहीं है. ठीक है, if it is expressly written, I am relying on your words, I haven't read that provision, but if it is expressly written that all offenses under this act are cognizable, then part 2 will not be applicable in the same sense that it would be applicable to any other law.
So they've said only in certain limited purposes.
So certain limited purposes, maybe it is somewhere defined that whether they shall be treated to be cognizable for the purpose of arrest, for the purpose of filing FIR, or for the purpose of investigation. तो वो उसका मतलब है वहां पे.
हाँ जी, thank you so much.
ठीक, हाँ. Because the purpose behind classifying offenses into cognizable and non-cognizable is mainly threefold. One is to decide power of police to arrest without warrant, to decide duty of police to register an FIR, and right of the victim to register, to lodge an FIR, and to decide whether investigation can be conducted by the police in that particular case. So it could, that expression certain limited purpose may be referring to either of these three or all of these three. So that I may know by reading the entire act. But purpose are threefold. Now coming to the distinction between these two kinds of offenses, that cognizable offense and non-cognizable offense. Now, first distinction is very simple and regular also. Whenever you are distinguishing between two concepts, legal concepts, then if those concepts are provided under two different provisions or under two different provisions of two different acts, or they are given under in a judicial decision, then you must mention it at the outset. जब भी आप उसके बीच में differentiate करो. So therefore here also you should mention that cognizable offense is defined under 2C and non-cognizable is under 2L. Now, the second distinction we have discussed. So therefore, I will be just referring to it. If it is a cognizable offense, then police officer may arrest without warrant. If it is a non-cognizable offense, then police officer has no authority to arrest without warrant. Now, third distinction is on the basis of Part 2, what is provided under Part 2 of Schedule 1. In case an offense is there in a law other than IPC, then whether that offense is a cognizable or non-cognizable offense shall be decided on the basis of the formula that is given. So if the punishment for the offense is less than 3 years, then it shall be treated to be a non-cognizable offense. If it is 3 years or more than 3 years, then it shall be treated to be a cognizable offense, more than 3 years. Okay? Now coming to next distinction, and this is the second purpose behind classifying the offenses into cognizable and non-cognizable. पहला तो था to decide on the power of police to arrest. So दूसरा है duty of police to register FIR or your right of the victim to register an FIR. This is the second purpose behind making a classification of an offense into cognizable or non-cognizable. So therefore, first FIR can be registered if the offense is cognizable. FIR can be registered if the offense is cognizable. If the offense is not cognizable, is a non-cognizable offense, then even if you go to police station, according to section 155, if the offense is non-cognizable, so police will not register your FIR. It will just mention a line in general diary. एक पुलिस थाने में जनरल डायरी होती है, विल टॉक अबाउट इट, वो पुलिस वाला वहां पे लिख लेगा उसके बारे में जो भी आप इंफॉर्मेशन दोगे, एंड देन ही विल आस्क यू टू गो टू द जुडिशियल मैजिस्ट्रेट, इलाका जुडिशियल मैजिस्ट्रेट मींस जुडिशियल मैजिस्ट्रेट व्हिच हैज अ जुरिसडिक्शन इन दैट एरिया वेयर द ऑफेंस हैज बीन कमिटेड. उस एरिया में जिसका जुरिसडिक्शन होगा उसके पास वो उसको भेज देगा मैजिस्ट्रेट के पास. सो देयरफॉर सिंपली स्पीकिंग, if the offense is cognizable, then FIR can be registered. It does not mean you cannot file a criminal complaint. We will discuss that. It does not mean you cannot file a criminal. You can file a criminal complaint because there is no embargo on filing a criminal complaint on the basis of cognizable and non-cognizable offense. But जहां तक FIR फाइल करने का सवाल आता है, because cognizable offenses are serious in nature. वो तो आपको इसको पढ़ के भी पता चल गया होगा थोड़ा सा, एंड इफ यू रीड आईपीसी के डिफरेंट प्रोविजंस यू विल गेट एन आइडिया, बिकॉज कॉग्निजेबल ऑफेंसेस आर सीरियस इन नेचर एंड in criminal law jurisprudence serious offenses are considered to be offenses against state. That is why there is a provision that you can register an FIR in case of a cognizable offense. But if the case is of a non-cognizable offense, it is a non-cognizable case, then no FIR can be registered. So this is the second purpose that is served by classifying offenses into cognizable and non-cognizable. Now, third purpose is that in case of a cognizable offense, because police has the duty to register an FIR with certain exceptions, but just say that one can register, lodge an FIR in case of cognizable offense. So therefore, police will get the power to investigate the case. Now, in case of non-cognizable offenses, as per the provisions of section 155, no police officer shall investigate a non-cognizable case without the order of magistrate. magistrate. So this is the third purpose that is served by classifying an offense into cognizable and non-cognizable. So in conclusion, हम क्यों किसी अपराध को कॉग्निजिबल और नॉन कॉग्निजिबल की श्रेणी में डिवाइड कर रहे हैं, इसके तीन उद्देश्य हैं. पहला, ये डिसाइड करना कि पुलिस अधिकारी की या ऑफिसर इंचार्ज ऑफ पुलिस स्टेशन की पावर है क्या अरेस्ट करने की विदाउट वारंट, ये हमें पता चलता है. ये पहला उद्देश्य है. दूसरा उद्देश्य ये है कि क्या इस ऑफेंस के बाद, कमीशन के बाद, क्या मैं एफआईआर करा सकता हूं या नहीं करा सकता हूं. तीसरा उद्देश्य ये है कि क्या पुलिस इन्वेस्टिगेशन, अन्वेषण कर सकती है या नहीं कर सकती है. अगर कॉग्निजेबल ऑफेंस है तो पुलिस के पास पावर है अंडर 156 ऑफ सीआरपीसी टू इनिशिएट इन्वेस्टिगेशन. अगर अपराध नॉन कॉग्निजेबल है, देन पुलिस कैन नॉट स्टार्ट इन्वेस्टिगेशन, एंड द ओनली वे it can initiate an investigation, or the moment at which it will start an investigation, it will be when it will receive an order from the magistrate. So police can investigate a case involving a non-cognizable offense only when it has received an order from magistrate. तो जब तक मैजिस्ट्रेट आदेश नहीं पारित करेगा कि फला फला मामले में, बिकॉज इट इज ए नॉन कॉग्निजेबल ऑफेंस, पुलिस को इन्वेस्टिगेशन करनी है, तब तक पुलिस इन्वेस्टिगेशन नहीं कर सकती उस मामले में. डज नॉट हैव द पावर टू इन्वेस्टिगेट दैट ऑफेंस. तो ना तो अरेस्ट कर सकती, ना इन्वेस्टिगेट कर सकती, और ना ही एफआईआर लिखी जा सकती है किसी नॉन कॉग्निजेबल मामले की. इफ इट इज ए कॉग्निजेबल ऑफेंस, तो पुलिस हैज द पावर टू अरेस्ट, पुलिस हैज द पावर टू इन्वेस्टिगेट द ऑफेंस, एंड पुलिस ऑल्सो हैज ए ड्यूटी, नॉट पावर, ड्यूटी टू रजिस्टर एन एफआईआर. So that is all for today. If you want to ask something, then you can go ahead and ask. So I'm stopping here. I'm done with today's lecture. Tomorrow we will start with what are the different modes of initiating a criminal case. ये तीन पर्पस तो समझ आ गए ना आपको, व्हाई यू आर क्लासिफाइंग ऑफेंसेस इनटू कॉग्निजेबल एंड नॉन कॉग्निजेबल.
यस सर.
और ये भी समझ आ गया कि भैया लिस्ट आपको बनाने की जरूरत नहीं है, यू जस्ट नीड टू रेफर टू सीआरपीसी का शेड्यूल. सो यू डोंट हैव टू क्रैम इट कि कौन सा अपराध कॉग्निजेबल है, कौन सा नहीं है. जस्ट go to CRPC, flip through the pages of first schedule, and you will get to know which offense is cognizable, which is not.